Bismillah ar-Rahman ar-Rahim. The topic before me today is istishab. Istishab literally means escorting or companionship from the Arabic root sahuba, to accompany. And the basic idea is simple. What we have known in the past, whether a state of fact, rule of law or reason, is presumed to continue in the present unless we know that there is a change. For example, if A had owned a house and he is absent for 30 years, maybe longer, he is still presumed to be the owner. And the mere doubt that he might have sold it or maybe he is no longer the owner will not qualify. The Hanafi school, Hanbali, Zahiri, and Shia Imamiyya accept istishab as a proof of Sharia. But the Maliki, Hanafi, Ash'ari, and Hassan al-Basri, they do not accept it as a proof in its own right. Some have even said that istishab is a rule of evidence, not a proof, but it is a presumption in the sense that it presumes that the continuation of that which has existed or which had not existed in the past. This also refers to the rules of Sharia. The rules of Sharia, sometimes they are time bound, like the contract of ijara is by its nature is time bound. We will not presume the continuity of that contract become beyond its stipulated time limit. And the rules of Sharia are otherwise presumed to continue and remain in force unless they are abrogated or there is any change. But some provisions of the Sharia, such as the Quranic provision on the testimony of witnesses who have committed a slanderous accusation, is that you never again accept their testimony. This is a permanent position, and the rules of istishab will not apply to it. Istishab is a presumption, and for that reason the ulama maintain that it is the last ground of fatwa, akhir madar al-fatwa. We refer to other proofs, whether it is qiyas, maslaha, ijma, or other proofs, and only when none of these can be of any help, then we refer to istishab. In the case of a missing person, for example, no information is available about his whereabouts, whether he was alive or dead. But the last thing we have known about him or her is that he was alive. So we presume him to be alive until there is some evidence that the situation has changed and he is no longer living. With regard to claims, we presume the opposite. If someone claims that A claims B owe him 1,000 ringgit and A denies it, we presume that the claim is unproven unless it is proved. It is a rule basically grounded, istishab is basically grounded in rationality, but there are proofs of Sharia also in support of it. People of sound nature, the Ahl al-Urf, it is natural for them to presume the continued validity of the facts that are known to them, whether it is a contract, a rule of law, or certain customary provision. What they have known, they will presume and will act on that knowledge unless there is a change. If we know that Ahmad has been an upright person, we will presume that to continue unless we know that something has changed. And the change that occurs may be in the state of facts or the rule of law or the essence of something. The rule about drinking liquor is that it is prohibited. Until there is an abrogation of this or change in the essence of wine, if it changes to vinegar, for example, then we will no longer presume the original state. Istishab occurs in 4 varieties, and these are fairly straightforward concepts. The first one of this, the presumed continuity of original absence, istishab al-adam al-asli. Certain attributes or facts had been non-existent in the past, we presume them to remain as such. If a person had not acquired educational qualification, is an ignorant person, we presume him to be unqualified unless we know he has obtained qualification. Similarly, a child, a minor person, remains a minor person unless the condition changes, he becomes adult. And this also extends to the idea of the presumption of innocence. People are presumed to be free of liability. No liability is attached to them. The original state is non-existence of liability and guilt, and we presume that to continue unless it is proven that this is no longer the case. The second is the presumed continuity of original presence. If we know a state of fact that had existed, A had been indebted to B for $1,000, that state was known to us and it's presumed to continue unless the debt is paid and the situation has changed. The husband remains positively responsible to support his wife unless there is a change in the state of marriage. The third variety of istishab is presumed continuity of the rule of law, istishab al-hukum. The rules of Sharia are presumed to continue, the rules of halal and haram. Unless there is a change, they are abrogated or situation has changed. Should there be no ruling concerning a matter, then by one of the legal maxims that is grounded in istishab, and I will discuss a little later, is the presumption of ibaha, original permissibility. If there is no evidence, then we presume things to be permissible, although not everyone agree with this. And the Mu'tazila maintain, strangely enough, everything is presumed to be prohibited unless we know they have been validated or made lawful. I said there is rule support in Sharia also for istishab in the original principle of permissibility. In the Quran, Surah 2, verse 29, هُوَ الَّذِي خَلَقَ لَكُم مَّا فِي الْأَرْضِ جَمِيعًا. He is the one who created all that is in the earth for you. وَسَخَّرَ لَكُم مَّا فِي السَّمَاوَاتِ وَالْأَرْضِ. And He subjugated to you all that is in the heavens and the earth. The address is, of course, humanity generally. All that is in the universe is subjugated to the benefit of mankind, and therefore the permissibility becomes the original state. They are entitled to utilize everything they see within its limits, and that becomes the original state. The fourth variety of istishab is the presumed continuity of an attribute, istishab al-wasf. For example, we see water. We presume that it is clean unless we see that there is a change in the taste or color, or we know presumed continuity of an attribute. Cleanliness is an attribute. A person who is in a state of purity or tahara or wudu is presumed, this attribute is presumed to continue unless there is knowledge that it is no longer the case. If a person forgets whether he is still in wudu or not, he can take it, the presumption would be that he is still in that state unless he know it has been changed. The ulama are in agreement over the first three varieties of istishab. There is not much of a disagreement, but essentially. But the fourth variety concerning the presumption of attributes is subjected to disagreement. The Shafi'is and the Hanbalis accept the istishab al-wasf both in the affirmative and in the negative sense. But the Hanafis and the Malikis accept it with some reservation. We give here the example again of the missing person. And the Shafis and Hanbalis entitle the missing person, since the last thing we know was that he was alive. If during this time one of his relatives dies, he can take a share and he can inherit from others because he is living. But also he can acquire new rights. And that is the istishab. The reason that we ground our position on istishab is good, both lidaf'a wa likasb, for acquiring new rights as well as protecting the existing rights. No one will inherit from him because he is still presumed to be alive. But the Hanafis and the Malikis will not entitle him to either. He cannot inherit, and no one can inherit from him. No one can inherit from him because he is presumed to be alive, but they say, the Hanafis and the Malikis, that this is only a presumption, it is not a fact. This is good for the protection of his existing rights. If he is married, his marriage remains intact. If he owns certain property, that will remain, but he cannot acquire new rights. Therefore, if one of his heir as his relative dies, he will not inherit. A share will be put in reserve for him until we know that the situation becomes known to us. This is the expression is that according to Shafis and Hanbalis, istishab can be used both as a sword as well as a shield. But the Hanafis and Malikis allow it to be used only as a shield, but not as a sword, so to speak. The disagreement here among the schools and ulama basically is over what it is that we think is the original state of things. And it is for that reason Ibn Qayyim says that we should not take a liberal recourse to istishab only when we have no other evidence. And in order to further develop this discussion, we bring into the picture some legal maxims of fiqh which are grounded in istishab. One of these is that certainty may not be overruled by doubt. Al-yaqeen la yazulu bishak. certainty is the original state, and it may not be overruled by doubt. If a person is known to be a sane and competent person, and that remains to be the case, and just any claim that he might not be, will not be given any credit. To give another example, if someone eats during the suhoor, the dawn time during Ramadan, it is dark still, and he is not sure whether daybreak has arrived or not, but he continues eating. Is he liable to observe another replacement fast? No. What is the state of certainty? What is the state of doubt? The night time is the certainty. The arrival of daytime is the state of doubt. Certainty prevails over doubt. On the contrary, if at the end of the day he is doubtful whether the sun has set or not, and he eats, takes the chances, and here he is liable to observe another fast. What is the state of certainty is daytime. Arrival of the night is a doubt. Certainty prevails over doubt. Another example that has become a subject of some disagreement is when a person pronounces talaq or a divorce, but he is not certain as to whether the words he uttered amounted to a single divorce or a triple and final divorce. Of course, if it's a single divorce, he is entitled to revocation and resumption of normal marital relations. According to Imam Malik, state of certainty according to the majority here is marriage, and that what is in doubt is the talaq. The certainty prevails over doubt, and the marriage still remains intact. Imam Malik, on the other hand, maintains that what is certainty is that talaq has been pronounced. What is in doubt is whether the right to revocation is there or not. And he says that the state of certainty now is not marriage, it is divorce. Certainty prevails over doubt. Raj'a or revocation cannot be founded in a state of doubt, so talaq, a final talaq, has taken place. Similarly, the presumption of generality is rules of law which occur in the sense in the general form or am are presumed to remain so unless they have been specified or qualified in some way. For example, there is a hadith, La yarisul qatil, the killer does not inherit. This hadith qualified the general terms of the Quranic verse on inheritance. Surah 4, verse 11, for example, that the male has double share of the female. It does not explain whether the killer and non-killer, or this has been provided, this detail, by the hadith, and the generality of that verse is now qualified by the presence of this hadith. Similarly, the direction of the Qibla was established by the Sunnah in the practice of the Prophet to be toward Jerusalem, until the verse of the Quran came in Surah 2, Ayah 144, to turn your faces toward the Masjid al-Haram, toward the Kaaba. فَوَلِّ وَجْهَكَ شَطْرَ الْمَسْجِدِ الْحَرَامِ. So the existing practice would have continued had there not been this new ruling which specified the original ruling. Had there not been this, we would have continued, we would have presumed the continuity of the original position. But Al-Shawkani says that there is no need for istishab. These details can be determined actually from the putting the two texts together. We can draw the conclusion, whatever that may be. The next legal maxim is Bara'a al-Zimma al-Asliya, to which I made a reference. This is original state of non-liability or the presumption of innocence, that no one is guilty or liable unless it is proven that they have committed a crime. No one is required to perform a Hajj more than once in a lifetime, nor to perform a sixth salat or prayer in a day, because they are not liable to do such a thing because this is not required. The original state of non-liability prevails. However, and no one can be punished for something that the law has not really determined to be an offense or a crime. But the Hanafis and the Shafis have disagreed in the application of this presumption of innocence or Bara'a al-Zimma, with reference, for example, to attempting a reconciliation or a compromise. If A claims that B owed him $1,000, B denies it. The question arises that the dispute still continues. Is it valid that compromise solution should be attempted by way of agreement or sulha? The Hanafi says yes, it is valid. Shafi says no. Once the claim has been denied, the original state of non-liability prevails. And in that state, it's not right to attempt a reconciliation of any kind. There's no guilt, no liability, prove it. If you cannot prove it, that state won't be prevail. But the Hanafi say that as soon as a claim has been leveled and the original state of non-liability is compromised and it is not fully operational, can take, for example, attempt at reconciliation. Lastly, we have referred to the norm. Original norm of Sharia with regard to things is that they are permissible. The principle of ibaha, al-aslu fil ashya al-ibaha. This is a very important, very well-known principle. Unless there is a ruling that overrules the state of permissibility, then we presume that things are permissible. With two exceptions. One is the munakahat, the state of relation between members of the opposite sexes. The presumption is that sexual intercourse is unlawful unless it is made lawful through marriage. Certainly concerning ibadat, matters of worship, the presumption is of non-permissibility. Unless we are ordered that we do sixth salat, we will not accept any presumption to change that. The Hanbalis have actually accepted the principle of ibaha more widely than the other schools. This can be the basis of commitment of iltizam. Like polygamy, if a prospective spouse enter into their marriage contract that the husband will not marry a second wife, is this valid? The Hanbalis say yes, it is valid, because polygamy, although permitted, is a permissibility, it's not an obligation. Permissibility can take iltizam or commitment. The Jumhur, the majority, says that we are not entitled, allowed to circumvent the rules of Sharia through our personal agreements. So here the Hanbalis extend the scope of ibaha. And lastly, this principle of istishab is been interpreted by Hassan al-Turabi in one of his writings, that this does relate to the Western law doctrine of natural law and natural justice. The Sharia did not bring a new slate. A great deal of the Sharia confirms what has been known and existed in the past. When the Quran, for example, provides for Amr bil Ma'ruf, promotion of good and prevention of evil, or when it says that God commands justice in the doing of good. Some of the good and evil are regulated by the Sharia. A great deal of it is not. And it is known by reference to the nature of things. So there is this, one can liaise the principle of istishab, link it up with the natural law and natural justice principle of Western jurisprudence. Some have said that istishab is a rule of evidence, as I earlier mentioned, but when you look into the detail, it is a principle that is advocated mainly by those schools who are a little restrictive in accepting other proofs. And the Shafi'is and the Hanbalis accept it more than others. Thank you.